Okay, at this point, why don't we turn it to the audience?
Professor Dill, if I could ask the first question? Since I have a monopoly on the microphone, I'll take advantage of it for right now. So the question relates to the last comments by Professor Henderson and Mr. Senator about, or even Professor Henderson, I can reference the comments you made earlier about prosecutors not being finance professionals, not being accountants. They are going to do what they know or what they know best or whatever's in their comfort zone. And that kind of relates to this anecdote, if I could lead with, before becoming a law student, when I worked as a compliance officer. And the bank that I was at, to roll out a new KYC AML program, temporarily changed the performance metrics on the bankers for 1 year from 10% to, I believe, 40%. When that happened, we as compliance officers thought that our phones are going to be ringing off the hook, that the bankers were going to be jumping over themselves to make sure that we had everything we needed because the monetary incentive behind their compliance had quadrupled overnight. Surprisingly, the reality was that it had zero effect. It almost went so far as to do damage. They pulled back even farther in a response that their monetary incentives were on the hook of compliance, vice being revenue. And the reason why I referenced your comments, Professor, was maybe it's old dog, new tricks, or maybe asking them to do things outside their comfort zone because they wanted to sell, they wanted to make revenue. But with that type of example in mind, and going back to what you were talking about, Mr. Senator, as far as values or culture or people self-regulating, what is your thought on getting to an environment where bankers or salesmen or people who are focused on revenue can get to a position where they are concerned themselves rather than handing off to a compliance officer their compliance responsibilities?
That's right in your wheelhouse. Okay.
I guess there's always carrots and sticks. Let me start with the carrot. Maybe it's a lot to ask for certain types of people, but don't underestimate the power of a great value system in a firm. There's been research on this. I mean, some of it is fairly dated now from the Compliance and Ethics Leadership Council. It sort of talks about this dynamic in firms where not only do you have the tone from the top, but it's so infused in the firm by people modeling certain behaviors that you actually almost have a neighborhood watch where the people, there's aligned people in the firm feel so tied to and feel so sort of committed to the mission-driven firms do this really well, that they become everybody becomes a compliance officer in terms of just the culture of the firm. And in many respects, that's a huge driver. That being said, you mentioned people that are revenue generators. Incentives are really important. I mean, to the extent that people, I think there was one study, I can't remember this one, had to do with maybe trying to kind of deal with getting more cars through the assembly line. I'm going to mix this up. I don't know if you remember what this one is, but what happened was that the metric was getting things through quickly. That happened. All of a sudden, all hell broke loose in terms of defects that, the incentives were really just went awry. So
I think there was an I Love Lucy episode. It was the chocolate.
and you just couldn't eat them fast enough. But the thing is thinking about incentives. I mean,
you get what you pay for.
So in terms of, is the business quality business? Look what happened with Wells Fargo. I mean, thinking about ways to sort of modulate that, whether it's through clawbacks, whether it's other things, whether you actually are compensated for sometimes the business you don't take in terms of whether it's not good business. Who knows? But the incentive system will hopefully reflect the value system of the firm, and hopefully if it's done well in the firm, there'll be a handshake.
So just very quickly, I'll go back to my prediction markets thing. So I'm all for good values, and that's going to work in some firms. But if you're running something where it's, people are salespeople and they're really trying to sell things, and that's how they measure themselves, is basically like some kind of scorekeeping. These guys are guys and gals are gamblers, and that's what makes them great salespeople. Deploy their natural instinct to be bettors, gamblers, by setting up a market inside the firm. It might look like this, and Google does these all the time. We're going to have a contract that pays $1 if one state of the world happens and 0 if another state of the world happens. And that state of the world could be anything. Are we going to restate earnings within the next 5 years? Will we be discovered for having violated some FINRA rule or SEC rule in some sense in the next 5 years? We just make whatever term we want, the thing we're trying to identify. And if it turns out to be true, you hold a contract, you get $1. And if it's not true, you don't get $1. And then we make these tradable within inside the firm. So now if I'm someone on this desk who knows that we're all acting completely against FINRA rules, and I'm part of it because I got to dance while the music's playing, I'm also trading anonymously in this intra-firm market, betting that we're going to get caught. And so if I see this contract is trading for 50 cents, which means, it's about 50% chance we're going to get caught by FINRA, I'm going to start buying up these contracts because I know we're going to get caught because we're doing something that's clearly bogus. And then the managers at the top, when your CEO comes into work in the morning, she just opens up her laptop and she sees 50 different contracts. Are we going to restate earnings? Is this trading desk acting badly? She sees these things, and it's just like stock prices. Red light, green light. And if she sees that, these stocks are trading at 80 cents on whether or not FINRA's investigation will reveal that we were engaged in manipulation, I better go down there and kick some butt to find out what's going on. So that's a way of deploying people's natural incentives to reveal, because what you want is people to reveal the information that there's cheating going on. So we can be creative and come up with things like that happen within firms that may work just as well as this culture of values.
But most of the time, it's not so obvious that people are cheating. In fact, the people will tend to not see themselves as cheaters, and they may not. Your market might get distorted in terms
That's
of.
right.
So and sometimes you can't predict whether, because there is some degree of flexibility, shall we say, in how law enforcement might interpret a particular rule. You might not be able to predict that you're going to end up in the same.
I guess I have a related question through analogy. I can use that, sure. Thanks. So I'm really more familiar with healthcare compliance, HIPAA kind of stuff, and now with HIPAA, with my understanding of it, part of the incentive for people in healthcare professions to comply with HIPAA is there's an individual incentive. If there's a violation of compliance with HIPAA, it follows that person individually in a lawsuit, and individuality and accountability and liability to yourself is certainly an incentive. In talking about compliance in financial institutions, is there similar individual accountability that's driving people to understand compliance?
Yes. Yes, in fact, that's a traditional part of the securities regulatory regime. In fact, for many years, the fundamental remedy that both the SEC and the SROs had was to kick somebody out of the business, suspend them, hang a reputation, essentially, a record on them that would follow them. So that's still a critical part of securities regulation.
And we see this, to the judge's point, I think every FINRA disciplinary proceeding I've been involved in 3+ years, it's a low-level guy, and one of their defenses is, why aren't you going after the big guys? And it was like, well, they're not here before. And every single time, somebody from one of the firm representatives, the small firms especially, says, why aren't we going after the big guys? And the response from the FINRA people every time, general counsel, is exactly the same. They should have a button they play, which is, I don't know, that case isn't before us.
What do you see as the role of whistleblowers? Because I know there was a lot of whistleblowing in the Wells Fargo case, and it seems like there are a lot of instances where people try complaining within their company and they don't get much of anywhere.
Yeah, so there's a good paper about who blows the whistle on corporate fraud by my colleague Steve Kaplan at the business school. It's usually not whistleblowers inside of firms, and whistleblowers, even the heroes, it basically ends up ruining their lives. People at WorldCom and other frauds, the whistleblowers who came out, their lives were not celebrated as heroes. So one thing I think we should do, the government has some programs where they encourage, there's a program called Key Tam, I don't know if you're familiar with this, where they basically pay people to bring lawsuits where the government is defrauded. And so if you work for Lockheed Martin and they're ripping off the government and you bring this to the government's attention, the government considers it. If the government sues and wins, you get a reward. And these rewards they can be millions, tens of millions of dollars. So I think we should do way more like that. A big problem is that Don was going to talk about is insider trading is a way that you could blow the whistle in a very effective way. One of the most famous SEC cases was one of these guys who sort of did this on a big Ponzi scheme. Of course, the government went after him and tried to punish him for no good deed goes unpunished. One thing you could do is you could imagine paying people a lot of money to blow the whistle on corporate fraud to ease the downside of their life becomes, they lose all their friends and everything like that. So I'm in favor of the government paying huge bounties for people who blow the whistle on corporate fraud.
Well, and one of the things that came out of Dodd-Frank was the SEC's whistleblower program, which really is modeled much as Todd described, where there is the potential for very substantial financial rewards for people who blow the whistle, and there's a significant financial recovery as a result. That has brought thousands of tips, complaints, and referrals into the SEC. Some of them are of more quality, better quality than others. One of the things that we found, though, is that I think the last figure that I saw was that of the whistleblower awards given by the SEC, in the neighborhood of 80% of those individuals had complained first to the through internal channels. And I think one of the concerns when the program was enacted was, are we creating a sort of bounty system that will undermine internal compliance programs? And I don't think anybody thought that was a good idea. But we've been pleased to see that that's not been the effect. One of the factors that the agency considers in determining the amount of an award is whether somebody has tried to go through internal processes first and cooperated with internal compliance folks.
I just have
The other, just to point out quickly, the other thing that the Dodd-Frank Act did is it added anti-retaliation provisions, or built on the Sarbanes-Oxley's anti-retaliation provisions, to protect whistleblowers from retaliation by employees. And so not only did it enhance financial incentives to actually blow the whistle, but then to protect after the fact, hopefully making lives a little less miserable than to go to Todd's point.
We should realize, though, as David pointed out, these things are not free. I spent one summer working for the Antitrust Division, and they're the only Department of Justice branch that does their own investigations. And my job that summer was entirely fielding phone calls from people alleging that somebody was doing an antitrust violation. And when I asked why they gave me this really important job, they said, all of them will be competitors within an industry secretly calling, hoping that you will then launch an investigation against one of their competitors, and knowing it will never result in anything. But the fact that the government has started an investigation is something that we can use as a competitive advantage. So I'm in favor of them, and this is a really smart way to do it, where you're forcing people to exhaust their remedies inside of firms. It's not free.
I just wanted to raise a personal story from Moody's. I was at Moody's for 19 years, and a personal friend of mine, as a managing director in a derivatives group, he basically blew the whistle, testified in Congress, and for the next 4 years, he had young children. He was basically out of a job. He finally found something at the National Association of Insurance Commissioners.
I just want to bring something in, as long as we're talking about whistleblowers, and I want to go back to Judge Friendly, that Judge Rakoff had mentioned, and Judge Friendly's idea of the private attorney general. And when we're thinking about markets, or we're thinking about whistleblowers or deregulation, something that we very rarely think about is the ways in which plaintiff lawyers have had so many hurdles put in front of them that they can't act as, quote, private attorney generals. And I think that hurts the entire market. But when we're talking about incentivizing people to perhaps bring suit in qua tam actions, well, we've really hurt the ability of the plaintiff's bar to be able, in fact, to do that. So I just want to throw that out there, and maybe we can pick it up on a next panel.
Yeah, Professor Henderson, I just had one reaction, and you've said it a couple times. There's a cost to everything. Even in your private markets, how are you going to set? Who's going to? They have to be set up. They have to be monitored for some kind of fairness. And aren't the employees going to be trading more than working?
For sure. There are costs to everything. You're right. I use that example because Google famously has thousands of these markets. And they originated at Hewlett-Packard. Hewlett-Packard's, this was in the 80s, one of Hewlett-Packard's managers was frustrated that every time a new product was developed and sales were estimated by the sales team for how many of these printers they were going to sell, they always overestimated. And so someone said, well, why don't we just discount by this, historical experience? And he said, well, I have an idea. Why don't we ask people inside of the firm, engineers, salespeople, marketing people, to guess how much there was going to be? And they had these guesses basically traded in the market. And lo and behold, the market guess predicted this printer sales way better. So they did this experiment over dozens of years. And systematically, the market predicted sales within Hewlett-Packard way better than any other metric they could come up with. So I have no idea whether firms should be using these things or not. I'm just pointing out there are alternative ways to get information up to the top. They're subject to manipulation. They have costs. They have distraction costs, setup costs, monitoring costs, all these things, just like internal control systems do. So my only objection to Sarbanes-Oxley is not that there wasn't a problem to be solved, but that it said, we the government, not government, we Congress, we know how firms should be getting information flows up to the top to police fraud, and we're going to apply that to every firm in the economy. That's impossible. There's no way that's right. So instead of it being designed locally for different options, it was imposed by Congress people. And, I don't know if you know very many Congress people, but there's no way they got that right.
Okay, so anybody else? Yeah.
I feel like I've been defending compliance departments, but to Todd and Chuck's points, I think actually the trend is that compliance personnel value simplicity, not complexity. They're taking the rules and making it easy to understand for the workforce. I mean, one of the things that you see is as a public company, you're required to disclose your code of ethics. I mean, that's one of the required disclosures. And you're seeing a great trend away from a standards of conduct, which is usually a rule book of 65 pages of things to do, to principles of conduct, which are usually a very tightly written, tightly written principles for employees to serve as guidance for. So I think that there really is a trend to go to complexity, to go to simplicity for the
So let me just be clear what I meant, because I think I misspoke or I was misunderstood. I don't mean that that you're trying to create the complexity necessarily within your firm. You benefit from complexity of the rules, because then you're needed as a translator of that complexity. If the rules were very simple, then the compliance intermediated role is unnecessary. Just like if law was really simple, we wouldn't need as many lawyers. So lawyers have a desire to make things really complicated. Constitutional law teachers, they love when there's a 20 different part test provided by 6 different justices and they've got to be able to explain to their students. If it was really simple, A, don't do A, boy, we wouldn't need a lot of con law professors if the law looked like the 10 Commandments. So that's my only point. Not that you benefit from, or you try to spin complexity. You just benefit from complexity.
Yeah, but I think
Let me jump in with 2 thoughts, if I could. And sir, I understand what you're saying, and what I hear you to be saying is, as a compliance professional, you have to operationalize the rules. And not to tell war stories, but I was was just made counsel to Arthur Levitt when he was first came into office as a chairman. And there was a rule proposal. And another counsel and I, who went on to become a commissioner, fairly notorious for his deregulatory attitudes, we decided we were going to take this large, ungainly, complicated body of information in a rule, and we were going to make it simple. We were going to say, you know what, the standard should be don't commit fraud and otherwise be reasonable, or words to that effect. And we were really pleased with ourselves. We thought it was great. After that was proposed, and I'll spare you the details, Chuck, I think you know what rule I'm talking about. Yes, that Chuck looks like he remembers. This is a long time ago. After that rule was proposed, people in the industry who was supposedly designed to help lined up to come in and say, don't do this to us. Don't tell us be reasonable. We've got to write computer programs to say, do A, don't do B. If you exceed X percent, stop. Well, how do we do that if the standard is reasonable? So Todd, I hear what you're saying, and it's an interesting perspective. On the other hand, I think a lot of times, sir, is I think you put your hand up and said, you know, it's not that people in the business are saying, give us complication, I would say, not complexity, but give us things we can operationalize. Give us things we can put into practice in our firm.
So at this point, I want to ask the judge if you have additional questions or comments. At this point, we'll take a break if not.
Well, with a great apology, because I know everyone's very anxious to take a break, I will tell a war story of my own that will take about 2 minutes, but I apologize for it taking so long. So, but it illustrates the difficulty of being a whistleblower. So after the Foreign Corrupt Practices Act was passed, which, by the way, is, I think, one of the areas that a lot of compliance initiatives have to grapple with, and it's very difficult because it certainly involves third parties, and they're usually third parties in a different country. But in any event, there was a company in the United States that sold a lot of its product to third world countries, and it did so by paying bribes to a high-level minister in certain countries, and it was a pay-to-play situation. Its main competitors were French and German companies. They all paid the same bribe to each of these ministers, and then the minister selected on the merits. The Foreign Corrupt Practices Act comes along. The French and Germans in those days could still keep doing this, but the Americans could not because of the new law. So they asked a specialist who they had never used before. Instead of going to their regular general counsel, they went to a specialist at another law firm who, I'm sorry to say, had recently been a commissioner of the SEC. And the advice they got was set up an offshore company, staff it with people you can trust, then divorce yourself completely from the offshore company and sell all your product to the offshore company, which had about 4 employees, billions of dollars of sales, and let them sell it to the third world countries. And as long as you don't know what's going on, you're safe.
Your Honor, would you care to mention the name of this?
No, for reasons I won't, although it is, if you do your research, you can find out which company it is. That was terrible advice, but I think was prompted by the fact that this fellow had just gone back into private practice and wanted to show how creative he was. They set that up, and then after a while, a few years later, they started getting bills from the head of this intermediate company they had set up, this offshore company, who was the perfect person for that role, by the way, a retired French general. And he kept sending bills that were like for billions of dollars, quote, for services rendered. And so that presented a real problem for accounting. Should we pay these bills or not? So the CEO went to his chief lieutenant, an executive, and he said, we're not supposed to know anything about what this company is doing, but you got to find out what these bills are for, because if he's trying to recoup from us the bribes that we're not supposed to be paying, that will sooner or later get us into trouble. If it's something else, we'll be able to deal with it. So the chief lieutenant, over the next year or so, cultivated the French general, and finally found out that the French general was just making up these bills for, and then it was taking the money and putting it in his own private Swiss bank account, because he knew that from the way this had been set up, the company could not inquire about it. So the chief lieutenant was about to blow the whistle when the French general, knowing that he had found it out, said, we'll split it, and you will put money in your Swiss bank account. And the chief lieutenant said, you got a deal. So that went on for a few years. And there was, the hero of the story was a very young woman, real estate lawyer. And this company, in the trend towards beefing up in-house counsel, they had a bunch of real estate holdings, and they had brought in a bunch of young lawyers to act in the real estate department. And one of the perks that the executives got was if they had their own house closing, this young lawyer would go and do the house closing for those executives free of charge, saving them the money. So she did the house closing for the lieutenant, and one day she knocks on his door, and he had gotten so casual about this that he was on the speakerphone with the French general plotting their next skullduggery. And he doesn't hear her, but she hears him talking, and she thinks he said, come in. So she goes in the door, and for about 30 seconds he doesn't see her, and then he sees her, immediately gets off the call, closes the door, and says, I need your personal legal advice. And she, thinking that it's another house closing or something like that, says, sure. He then gives her a cock-and-bull story about how he's shocked to learn that the French general has been paying bribes and putting money in addition into his Swiss bank account, and it's all so terrible. And she goes home that night. I'm sorry this story is so long, but it is interesting. She goes home that night to her live-in boyfriend, who happens to be a lawyer, a senior associate in a large firm in a not in Chicago or New York, another city. So there's a clue. She says, I need your legal advice. And she tells him the whole story. And her boyfriend says, well, first, I don't think a real attorney-client privilege was created, so I think you should go to the CEO and tell him everything that occurred. By the way, don't go to the compliance officer, don't go to the general counsel, go to the CEO, was his advice. And you must tell them to hire an outside firm to do a full independent investigation of this. And by the way, I'm coming up for partners soon. If you could recommend my firm, that would be particularly lovely. The hero of the story, the young woman, goes to the CEO the next day. She reveals everything that the lieutenant had told her, recommends that he hire an outside firm to do an independent, and say, the one firm you must not hire is my boyfriend's firm. By the way, that relationship soon disintegrated. But so they then brought in my firm. I was then in private practice, which is how I know all this. Eventually, it took us about 2 years to learn all the things I've just told you. It was not an easy investigation. But they then fired the lieutenant, and then the question came up, what should we disclose to whom? Everyone agreed we should disclose the misconduct of the lieutenant to the local U.S. Attorney's Office. There was a lot of debate as to whether we should disclose what the company had done in terms of setting up this whole thing, but eventually the board, in my view, correctly said, no, we got to disclose that to the SEC. So that was fully disclosed. The SEC agreed that since we had to the letter followed the advice of counsel, the company had done nothing wrong. The U.S. Attorney's Office brought an indictment, but then the defense raised that the whole thing was tainted because it was the fruit of a breach of the attorney-client privilege between the young lawyer and the lieutenant. And although the U.S. Attorney's Office thought that that would not ultimately prevail, they were worried about it, and so they let the guy plead to a misdemeanor, and he only got probation. And finally, about a year later, because I did no other work for this company other than the outside investigation, but just out of curiosity, I called up and learned that the young woman had been sort of pushed out of the company, very politely, with everyone saying what a great hero she was, but nevertheless, no one trusts a whistleblower, and so she was forced out. So, what I draw from that long-winded story is human nature is not so wonderful.